Please, Your Lordship. I pray for a listing a criminal appeal, criminal which was listed in the month of October for orders, my lordship.
Month of October.
Yes, my lordship. It was listed on the month of October.
Now,
I pray for
What do you want now? What do you want? What do you want now?
Pray for listing Friday, my lordship.
Next week, Friday.
Next week Friday. Oblige, my lordship.
May I please, Lordship? I beg to mention item number 6. This matter is wrongly listed in this bench. Kindly list the matter in an appropriate bench.
One person.
6.
No, you wait. These are listed for some other reason. You wait. You wait, we'll pass an order.
May I please, Your Lordship? I beg to mention item number 17, Lordship. I believe Lordship may not be liking to list up this matter, Lordship. Already our order was passed, may not
Sorry?
be taken up by this bench, Lordship.
More.
Item number 17. There's already an order. Somehow it again got listed.
Item 17, you write, let this matter be listed for hearing before any other bench without one of us, bracket, Justice A.T. Choudhury.
Highly obliged.
May I please, Your Lordships? Your Lordships, as regards item number 7, Your Lordship. Your Lordship, there is a misplace of the file, Your Lordship. I'm appearing on behalf of Mr. T. Dury for the petitioner. I pray that Your Lordship, the matter may be.
No, please wait, this criminal petition, these are all single bench
Yes,
matters, but
yes.
probably this is a monitoring bench.
Yes, Your Lordship.
So we are in any case not going to hear the cases.
Yes, Your Lordship.
So let us see, can you call bench, if you tell him to come here? Yes,
Much obliged, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing of a IA Lordship. Today, Lordship, what happened in this case, Lordship? I filed a IA Lordship on 6/5 Lordship and for grant of interim bail for only for 5 days, Lordship. For attend the ceremony of Sardo of the sister-in-law, the petitioner, Lordship.
no, you want it to be listed today?
Yes,
Today
Lordship.
is not possible,
Tomorrow is
can't help it. Same day listing.
yes, sir. Yes, Lordship. Tomorrow is his Sardo of his
You should
sister-in-law.
have mentioned earlier, why didn't you not mention on Monday? We can give it to you tomorrow, not earlier than.
Tomorrow, yes, yes, Lordship. I know this.
You have got copies.
But sister-in-law, Shraddh.
No, whatever, even if we reject, she is entitled to an order.
Yes.
Tomorrow.
Master.
I have instruction to withdraw item number 13, Lordship. May I tap in, Lordship?
Number 13, you want to withdraw?
Yes, Lordship.
Who is for the other side?
And for the other side, Your Lordship.
All right. You take down Mr. A.
A. Bhattacharjee.
Bhattacharjee, Learned Counsel for the appellant, submits that he has instructions from his client to withdraw this appeal without liberty. Full stop. Miss
H. Busher.
H. Bush, Learned Counsel is present on behalf of the respondent and does not have any objection if the prayer is allowed. In view of the above, this matter appeal stands disposed of as not pressed. Is there any interim order?
No, Lordship.
All right.
Obliged, Lordship.
Highly obliged, Lordships.
It's like the single bench of matter.
Of MP
No, yeah, for decision.
for decision. It is the Agora Justice Terminal.
Can I get single bench of matter division bench and all of that? You could change the jurisdiction. When the court is a criminal petition will have normally single bench. Under what? No, I think this one gives single bench.
Quantum punishment of the given.
Has that notification been changed?
I'll have to find out. It's a GoPro is fully.
Actually, I know, I will go by what.
Yes, yes.
We are going to-
My lordship, I'll have to find out that.
So if there is a chief recommendation that these category matters will be heard by civil bench,
Right.
it will be heard by division.
Right, right.
And to modify নকরা লাগে, division bench should not take this.
ঠিক আছে লর্ডশিপ এটার উপর ডিমান্ড যে ক্লারিটি দিব লাগে আমি একটু সার্চ করি
Lordship, in this case, your lordship, the challenge was to your lordship
Item number 3 to Matila.
framing of charge, your lordship.
Which is the main case. Item number 3 so on.
This is against revenue. I don't give out a good.
Sanctioning, without sanction.
So item number 3 is the main case.
Lordship 3 and your lordship 4, your lordship, these two are your lordship. Issue is your lordship whether charge can be, cognizance can be taken without sanction, your lordship, since there is a provision of section 124A is concerned, your lordship.
That is correct, but
Oh, no, tomato 7.
Mr. Mahanta. These are all matters pertaining to MPs and MLAs.
Actually, yes, ma'am. And these cases, my lord, listed because of this honorable apex care order. Has your lordship gone for the apex care order, my lord?
No, where is it?
That is, order, my lord, that is placed,
This is not.
order dated, my lord, 9/11/2023.
Item 3.
Probably that was item number 3,
So what is the operative part? Can you please read out?
my lord.
What is
My
the
lord, in
operative?
that case, my lord, there is a direction. In para 20, para 20, there is a direction.
What is the direction?
Direction, first direction is to, my lord, to monitor this, my lord, and to rename the name of the, that earlier it was Somoto. Now it is, my lord, the new name as a special bench, my lord. That will be rename, designated as MP MLAs in reference, designated court of MP MLAs. Somoto in case with para 20, your lordship got it, my lord.
Yes.
That para 20, my lord. Having considering the matter in details, we direct that 1 and 2 is, my lord, complied. Probably reason. And now, my lord,
Monitoring bench is not required to decide detail, not, this is the monitor, each and apex like slow motor title, investment, cases pending state ensure, comply with decision, or the decision should is to be heard by division bench.
now your lordship kindly come to para 12, my lord, of that order.
Yes.
Para 12, my lord. Para
Yes.
12, my lord. So came to that third, my lord. We are concerned with Arunachal, Assam, Mizoram and Nagaland.
Hmm.
So in case of, my lord, Assam, now, my lord, still 75 cases are pending. In case of, in case of Arunachal, 4 cases are pending. And cases of, my lord, Mizoram, 4 cases pending, Nagaland only 1. So what are the state of that, those, my lord, cases, my lord, that has to be, my lord, highlighted by the respective council of the state, my lord. So suppose, my lord, that your lordship kindly see a total case, my lord, in case of Assam, my lord, 75, more than 5 years, my lord, that is conviction, that is 33 cases. So what are the states, my lord? It lying in the district court, lying in the high court also, some, my lord, passing petition is pending. So that status, my lord, according to the status, your lordship can direct, my lord. Because this bench cannot hear that, my lord.
That's right. That's what we were confused.
My lord.
It seems there is.
That
some
is, my lord,
confusion.
that is what I understand, my lord.
Yeah, you're right. We also felt so. This bench is not supposed to
Yes,
hear our case.
because it is a single bench matter, cannot take up by, this bench is only to monitor. Suppose there is a delay, then you go, and that's why, my lord, your lordship kindly say give priority, that para 20 clause 4, my lord. That is very important.
Para 20, clause 4. Yes.
Though those who are, my lord, death sentence is there, that will get priority. But first, we have to know that how many such type of cases pending. So that has to be highlighted by the respective council of the state, my lord. Until and unless I will not get that clear picture. Because that was the affidavit file, they have some government, respective government file affidavit in our apex court, my lord. On the basis of that affidavit, this chart has been prepared, my lord. So this court only to, my lord, monitored, my lord, and give direction to expedite the matters.
So Nagaland and Mizoram, there is
Very
almost
less
nothing.
case, very less. As on, because that is the order passed on, my lord, 9/11/2023. That means up to December. So far is Assam is highest, my lord, 75, and Arunachal 4. But in respect of Mizoram, they shown the 0. Probably these are already disposed of, maybe. Yes, your serial number 18 and 19 of the death chart, my lord. So that let them, my lord, place the status, my lord.
All right, now,
That tribunal has to prepare. Or is that you will be directed to place them at the will and penalty Quran, which is this is for appropriate orders for unbeing listing. SCM raise are possible to get to program listing. Time also proceed on the time orders selling in still granted by the Quran unless place of the response extending. Unity change on operation. So finally it changing.
item 3 is the main monitoring.
Monitoring.
matter. Which are the other cases which have been listed along with it, which are single bench matters?
Lordship, item number 4, Lordship. I am in fact appearing for the petitioner, Lordship. It's a quashing petition filed against a proceeding going in before the judicial magistrate first class, Lordship, Kamrup Metro. But so far as my information is concerned, that case has got dismissed for default, Lordship, by the order dated 14/10/2022. So in that view, Lordship, although my petition becomes infructuous, Lordship, but till date, they have not filed any restoration, Lordship. No restoration is pending.
Is that correct, Mr. Deori?
Yes, Your Lordship.
Then we'll close it, item 4.
Only that liberty, Lordship.
You are challenging an order issuing summons.
Yes, Lordship.
Will you please cross check and tell us, don't say yes. We are going to record it in the order.
Lordship, the CR case number 1484/2019, Lordship, pending before the judicial magistrate first class, Kamrup Metro, Guwahati.
So, what is under challenge in criminal petition 228 of 2020?
Complaint case. Someone to issue, someone to lie.
That's all right. Let us proceed. I heard Mr. P. Nayak, Learned Counsel, appearing for the petitioner.
The complaint as well as the proceeding, Lordship.
Also heard, who's the APP here? Also heard Ms. S. Jahan, Learned APP, Assam, appearing for the state. Mr. T. Dodi, Learned Counsel, is present on behalf of the respondent number 2. This criminal petition is filed assailing the order dated 4/5/2019, passed by the Learned Judicial Magistrate First Class, Kamrup, (M), close, at Guwahati, taking cognizance of the complaint filed in C_R_ case number 1484 small c oblique 2019 and issuing process against the petitioner under section 500 oblique 501, oblique 502, oblique 34 of the IPC. Several grounds have been urged in the criminal petition. However, today when the matter is called up, Mr. Nayak submits that CR case number 1484C of 2019 had been dismissed for non-prosecution on, what is the date?
14-10-2022, Lordship.
On 14/10/2022, and no petition for restoration of the proceeding has been filed till today by the complainant stroke respondent number 2. The said submission has been confirmed by Mr. T. Devi, learned counsel appearing for the respondent number 2. If that is so, nothing survives for adjudication in this criminal petition. Full stop. With the consent of learned counsel for the parties, this contesting parties, this criminal petition stands closed as infractious.
Also, may I be brought simple liberty, Lordship, if a situation arises when he,
By granting liberty to the petitioner to approach this court once again, as and when a fresh cause of action arises.
Lordship, oblige, Lordship.
Yes, apart from that, which are the other cases?
Item number 7 also is Lordship.
Item number 7 also.
This single bench.
What about 6?
6 is more than 145 proceeding penalty for change rather than mentions only.
Item 6, you write, the petitioner's counsel. submits that
Lordship,
this
in this
matter
case, they are
pertains to single bench.
politicals and
Therefore, it
MLA.
has been wrongly listed before the division bench. Okay, full stop. Ms. S. Jahan Lane, PP Assam is present and supports the said submission. Full stop. Registry to therefore verify and list the matter before appropriate bench. All right. Then what about 1, 2, 5?
Your Lordship, 1, 2, 5, 10, and 11, Your Lordship. In these petitions, Your Lordship, same similar issue, identical issue has been raised of sanction, Your Lordship. In some cases, Your Lordship, LCR has been received, and in some, there is no LCR, Your Lordship. And so far as stay
What
order
about
is
7? What about 7?
7, Your Lordship. 7, he is appealed.
What
That's
is?
there, you're probably on order of the
District
district.
Acha, then, so item 1, 2, 5,
10 and 11, Your Lordships.
10 and
identical
11.
issue.
similar identical question of law
Law.
is involved. Then you write item 1, 2, 5, 10 and 11. huh?
No, 7 to 8.
Mr. S. Bhattakur, learned counsel appearing for the petitioner submits that all these matters have been listed before this monitoring bench today in view of the order passed in item 3. He submits that although identical questions of law pertaining to
Sanction, Your Lordship.
grant of prosecution sanction is involved in all these cases, yet these matters are otherwise to be decided by the single bench, full stop. In view of the order dated Azir order passed in item 3, registry to file appropriate report and list the matters again along with item 3 for further orders. Full stop. Then in item 3, you write. Order to break down. This suo motu proceeding has been registered in terms of the judgment and order dated from. No, actually, judgment order date. Judgment and order dated 9/11/2023 passed by the Honorable Supreme Court in WPC C capital C bracket number 699 of 2016, laying down certain guidelines for expeditious hearing and disposal of cases pending against MPs stroke MLS. Full stop. After the reconstitution of this monitoring bench, the matter has been listed for the first time before this special bench, along with the connected proceedings, namely item numbers. Item numbers 1, 2, 5, 10, and 11. Full stop. The cases pending against the MPs and MLAs in the 4 states coming within the 4 states, namely Assam, Nagaland, Mizoram, and Arunachal Pradesh, coming within the jurisdiction of this High Court, has been reflected in the table furnished in para 12 of the order dated 9/11/2023. However, we do not find any updated status report on record for passing fresh orders as monitoring bench. Full stop. Under the circumstances, this court is of the opinion that a fresh report is required to be called from the registry so as to facilitate further orders that may be passed in these proceedings. Full stop. We, therefore direct the Registrar General, Guwahati High Court, to collate relevant information and present a status report indicating the followings. Dash number 1. Number of cases pending before the principal seat at Guwahati, as well as the outlying benches of the Guwahati High Court pertaining to MPs and MLAs. Number 2, Roman 2. Stay orders as will be in bracket, if any, operating in these matters coming in the way of expeditious trial / disposal of these cases with specific particulars. Then main paragraph. A similar exercise be also carried out with regard to the cases pending before the district courts in the aforementioned 4 states. The report as called for by this court be placed on record before the next date of hearing. List these cases again on. We give them 1 month's time. Ready on. What did you think? 31st of May 2024. A copy of this order be furnished to the Registrar General, Guwahati High Court, as well as the learned Advocate General / Additional Advocate Generals of the state of Assam, Nagaland, Mizoram, Arunachal Pradesh. Yes. All district courts as well as the courts of special judges.
Number of cases along with the status of the case.
A number of cases along with the present status of the case. And next will be stay order if any operating.
For order that is 7.
Single bench matter, your lordship.
Why it has been listed here?
It's a single bench matter, your lordship. Because of that order only, it has been listed, your lordship.
Then it has to be
accused-
listed along with the other matters.
Yes, your lordship.
Acha, you add item 7. 7, 8, and 9 also. 7, 8, and 9 also. 1, 2, 5, 7, 8, 9, 10, 11.
Item 10, Paper book is ready here.
No, uh, in item 3, only one order where you named it. And in other matters, the same type of orders individually.
My lord, in this case, paper book is already ready, my lord, so it may come up for hearing.
Service के पास है service. Box of
What about service?
498A and
302, man. 302.
Is it necessary now after that judgment?
not required in 302 matters.
Informant.
302 हो जाना 307 days.
Conviction number 302. Yes, yes, yes.
So now service on informant is not necessary.
Not required, lordship can take it up for hearing.
Acha. I take down heard Mr. A.K. Gupta, learned counsel for the appellant. Also heard Ms. S. Jahan, learned counsel for the learned APP Assam appearing for the state. None is present for the informant respondent number 2. This appeal has already been admitted and the paperwork is also ready. Full stop. However, service report on respondent number 2 is awaited. Be that as it may, Ms. Jahan submits that after the decision of the division bench, in the case of what is it?
Deepak Nayak
Deepak
versus.
Nayak versus.
There 302 is not discussed. There only POXO matters are discussed and the directions are
It
issued.
has, so it has now been clarified.
Notification,
It has now been clarified that service of notice upon the informant
not mandatory.
in matters of this nature is not mandatory. Full stop. Therefore, this court may proceed to hear the appeal. Full stop. The said submission has also been accepted by Mr. Gupta. In view of the above, we direct the registrar to list the appeal for hearing in usual course.
Item 14.
There are also same, my lord, paper book is already ready, man.
Paper book ready, lordship, I'll still receive.
And what about informant?
But here also, my lord,
Lordships. Optional indicated,
my lord, here also 302, my lord.
not required. lordship.
Is there a notification person to the department? Then you write, we may proceed with the hearing of the appeal. We have perused the notification number 17 dated 15/3/2024 issued by the registry pursuant to the decision rendered in the case of Deepak Nayak Supra, and find that service of notice upon the informant in this criminal appeal is not mandatory, then rest will continue. So there is no private respondent here, is it?
Lordship, no.
Here also 302, my lord.
302, lordship, complainant is there. Notice should go, lordship, as usual process.
Take down. Heard Mr. A.K. Gupta, learned counsel for the appellant, also heard Ms. S. L. Boran, learned APP Assam State, appearing for the state stroke respondent number 1. As in view of the decision in the case of Deepak Nayak versus so and so rendered by this court. Service of notice upon the informant stroke respondent number 2 has been dispensed with in this case. The appeal has already been admitted and the paper book is also ready.
Yes.
In view of the above, on the request of learned counsel for both the sides, let this appeal be listed for final hearing in due course.
Item 15 of the daily list and item 21, 22, and 23 of the. It will be. In our objection, we can. করবি রে? কোনটু করবি?
Obvious, 16 in I.
This is a day one.
May it please your lordship. If this interlocutor application has come up for consideration for suspension of sentence and grant of bail, lordship. Here I have prepared one compilation of the deposition and the
Just a minute, just a minute. Interlocutory application number,
interlocutor application number 899 of 2023.
Seven of 24 over.
899, item number what?
Yes, it is listed as item number 15 and 21,
No, 15 is the main appeal.
main appeal, and 21 is the IA. 21, item 21 is IA,
So today you are only pressing item 21.
item 20. Appeal is already admitted.
Let us see item 21. Item 21 arises out of item 15, is it?
Yes, lordship.
There are three accused persons.
Okay, so how many accused persons have applied?
3 accused persons. I am representing item number 21 Bijoy Amse and item 23 Alauddin.
And who is for item 22, Mr.? So these three IAs arises out of the three criminal appeals.
Lordship.
Three criminal appeals, which are item 15, that is criminal appeal 355
Lordship.
and criminal appeal 1 of 24.
Yes.
Lordship.
So in one of the criminal appeals, there are two appellants.
No, they all 3 accused persons filed separate criminal appeals. Lordship.
Please, sub.
Okay, so 368 is the other appeal.
Other.
So these IAs have come up for the first time,
No, they have filed their objection.
Yes, yes.
and
It's on
LCR
record.
is also received.
LCR received.
Here. Yes.
Here in this case, Lordship,
Yes.
the appellants are convicted under section 302, read with 25 1 capital A of Arms Act, along with 307 for life, Lordship. Here, Lordship will find, just I have given one comparison. May I hand it over to your Lordship?
Yes.
Here, prosecution case is that one person, namely Lordship, that DK Namse, he was residing in his house. Suddenly, the informant and others went to near to his house. Then, from the house of DK Namse, someone fired, and accordingly, the one person died, and some other persons got injured. Now, here in this case, what your Lordships will find that DK Namse, who is not before your Lordship, he subsequently died during trial, Lordship. And DK Namse was having valid license. And he, while surrendering before the court, before the police after registration of this case, he said that the informant side attacked him and burned his house. That burning his house part, your Lordship will find in the evidence of the witnesses also, that it is admitted. And thereafter, he shot at towards the informant side, and one person died, others got injured. Now, regarding this present applicants, there is no specific role, Lordship, and it is admitted position that DK Namse shot from his gun, Lordship. Now,
DK Namse is the person who has died.
who died and who was having valid license. Now, subject to what my learned friend says, I have not found any evidence in the and from the record which shows that any other weapon was used in the present case, except that licensed arm, which DK Namse said that he used for self-defense. So involvement of these persons are not there.
So
And
this three persons have been convicted
Lordship,
with the assistance of section 34,
149.
149.
Initially, there were other persons who subsequently died, so 149 was there. And was subject to question what my learned friend said, what I have found here, Lordship, doctor was not examined firstly. And the witnesses PW9 who was treated to be an injured witness, his medical documents were exhibited, but through the IO, the doctor was not examined. And report
How
was
many persons died in the
one
conviction?
person, one person died, one,
And how many bullet injuries?
one,
Only one.
one.
But you say 5 persons, more than 5 persons?
Others, other more than 5 persons sustained injuries. The medical-
302, for 302.
Lord,
Or they
simple
were all-
injury with simple injury and bullet injury, they say.
So
medical
all
report.
5 persons were convicted under 149 for
Three
committing
persons
offense under 302. All 3
Three
persons
persons convicted,
under 302.
302.
Miss Jahan, something is wrong.
In fact, many fires were,
That's not the point.
Lordship.
That's not the point. If there is one bullet injury, then it must have been shot only once. So others have not shot. Others have not shot.
No, one bullet injury, he died, but then there are other firings done. So
No, no,
maybe
but the deceased received how many bullet injuries?
bullet injury is one, only on the deceased. But may
That's the
have,
prima facie case.
and of course, there were a mob fight. It was a
These
30,
are
40.
matters of final hearing.
But yeah, the injured witnesses are there. They said that we received injuries. Of course, one he had hit the bullet and he died.
No, no, that's
And
not
we
the point.
received-
We are on 302.
Hmm,
People who did not die, we leave them out. They
Hmm.
don't come here.
hmm.
The conviction is under 302,
Yes.
read with Arms Act,
Huh,
307
huh. And 149.
and 149. 149 is an assisting provision. So 302, unless they have involvement in either directly causing the homicide
Hmm.
or assisting in the commission of the crime, they can't be brought in. So there has to be a common object.
Hmm.
Correct. Common object has to be there. Now, obviously, one person has shot the fire. And that person, according to him, is a person who was holding a
Yes,
gun.
that is his story actually,
That
but
may be.
the prosecution story is
Since
that
when are they in jail?
They are in jail since 7/8/2023.
the prosecution witnesses said which one of the Khasia person has fired, we don't know. But then so many of them came and fired. It is his story that only one person fired and the one person died. But other witnesses say that so many of them came and started firing at us. So there were other guns which were not, for which
So
they did
who
not have,
died of the other guns?
and not died, but then injured.
Ask anybody, I don't know what is. What's that charge? Now, তিনটা aspect আছে। যেহেতু তিনটা obviously we have to show the human object which other person. And also possibly the one is fact that there is evidence to show that one decayed was holding a license. Not the one. I'm not. Not a license. That's it. Where is the finding regarding common object?
Lordship. And one more fact, I stand corrected, others have also sustained bullet injuries. PW 5 had sustained bullet injuries in his left arm.
No medical.
But that will not be 302. That will be 307.
He's surviving.
Then we are on 302.
We are on 302. But 149 is there. 149 findings. Lordship will
Ms.
see.
Rahan, you are very competent and knowledgeable in, why are you confusing things? We are on 302 now. Forget
Mhm.
307.
Hmm.
302 is the primary offense.
Yes, yes,
The
302.
lifer is for that.
Huh.
So you tell us on that.
What I'll say is on common object, because
Where
common
is the
object
finding?
finding I'll show. Uh,
Paragraph 40 and 41.
Then
Lordship will see, so paragraph 41
paragraph 41 of,
of the judgment, page number
no, but
23
where are you reading from?
from the petition.
First, let us start with the page, then we'll go to the
Right.
paragraph
Internal page 23
of
of the judgment,
In
which
the appeal
we'll find in.
the
Appeal.
appeal memo of Bijoy Amse. Appeal memo of Bijoy Amse, page 33.
Yes. Page number 33.
33 of the appeal memo.
Yes. Yes, please.
Lordship will see, on proper appreciation of the evidence on record, it is seen that more than 5 persons committed the offense of indiscriminating firing armed with gun upon the complainant side, which comes within the purview of deadly weapon along with forming an unlawful assembly. Therefore, I hold that the accused person in prosecution of their common object have formed an unlawful assembly armed with deadly weapon and fired indiscriminately at the deceased and the injured.
This is the case of acquittal because of this finding. Indiscriminate firing is not with an object. It's a complete oxymoron. in the
Yes,
face of the record.
indiscriminating firing is not in their object. Common object have formed an unlawful assembly with deadly weapon and fired indiscriminately.
You understand what has happened.
Not sure.
So for now, let's not blow it any further.
Hearing, we will see if I can make out.
So the same ground.
Same ground.
How many weapons have been seized?
One weapon.
One only. That was lying in the, because Armour's report is there.
Where is that one seizure of one weapon?
Page 61 of my compilation, your lordships will find.
No, we are not going into compilation again. We can't go on memo. Show from the judgment. Where is the testimony of the witness that they did not see who had shot the fire? Where is the finding?
Paragraph 46 of the.
Lordship wanted the witnesses,
They did
Lordships.
not say or point out who was role played by accused Francis. Same paragraph. Paragraph 46, page 24.
Paragraph 46.
Page 24. Internal page.
No, but these four accused, they are the applicants here.
Three accused
Three.
persons, three. They
Who
can
are the
answer
three who are applicants?
Bijoy Amse,
Vijay Amse, Alauddin,
No, please come to para 46 of the judgment.
yes.
On proper appreciation of evidence, please read it.
Ah,
Para
It is seen that the charges have been framed against 8 accused
para
persons.
46 of the judgment.
Paragraph 46 of the judgment. Upon proper appreciation, it is seen that charges has been framed against 8 accused persons. Amongst them, 4 had died or
Just a minute, the
Lord-
pages are not telling.
Page internal is 34.
Hmm?
Internal is 30, appeal.
You are referring to para 46 in page 34 of the memo.
Paragraph 46 of page 34.
Page 34, internal page 24.
Internal page,
24.
that's right.
Yes.
Para 46 starts with on proper appreciation. Yes.
On proper appreciation of the evidence on record, it is seen that charges has been framed against 8 accused persons, but it is clear that prosecution witness has vividly described how Alauddin, Bijay Amse and Sushyang Khashia has played their role in connivance with other parties in firing indiscriminately at the deceased and the other injured persons. However, though the PW stated that all the accused persons were present at the place of occurrence, but they could not say or point out what role was played by Sushyang, the other persons, the 4 people, in the indiscriminate firing, and in fact was completely silent about the aforesaid 4 accused person, and they are acquitted. 4 were acquitted. And remaining 4, I think 1 died and 3 were convicted. Or 1 was given a benefit of, no, these were given benefit of doubt. Doctor was an examine course. Doctor who conducted autopsy?
Report to Harvard exhibit police. It will pass.
Hani?
Judgment of hearing number.
এটা নাম্বারটা দিয়া নাই স্যার। দেখো নাই।
Exhibit P8 18 is the scissor of the gun. Scissor list of the gun, is it?
Yes, Lord.
There were 7 accused persons.
Lordship, initially, Lordship,
was
charge sheet
9.
was submitted against 10 persons.
Hmm.
And then 3 persons died. And against 7 persons, charges were framed.
And where is that person DK?
Lordship.
You said who was holding a licensed arm and
Lordship.
who died? DK Amse?
That is exhibited as the GD entry is there, page 53 of my compilation, exhibit 11. GD entry, he surrendered
No, where has it been dealt with in the judgment?
in the judgment. Also, that part is not discussed. Also, that
No,
therefore,
it is,
also I have
It is discussed in
Therefore,
paragraph
that's-
27, Lordship will see. No, others set fire to the DK Namse and tried to evict him. Therefore, in exercise of private defense, DK Namse opened fire, for which Hussain Ahmed died.
Para 26.
Paragraph 27. Page 26.
Page 26, you are referring to the memo of appeal.
Yes, memo of appeal.
Para number?
27. Memo of appeal? No, not memo of appeal. Paragraph 27, Lordship will see.
What is the paragraph of the judgment?
Paragraph 20, page 29. Paragraph 27. That is an argument made.
Hmm.
But this fact has not been established by any other witnesses, that it was only from DK Namse's firearm that he died. The story projected by the prosecution witnesses, all of them had come and fired and one died. DK Namse is their argument.
But who had fired that? There is no
And
evidence.
there is no evidence. Nobody could recognize who actually fired. One of the witnesses said, which Khasia person had fired, I have not seen.
They are in jail since
they are in jail since Lordship 7/8/2023.
Common object was to attack and stop them from cultivating. I think there's a the land issue. So the common object was simply to attack, and they carried those lethal weapons and they fired ultimately.
no, that's the problem. Where is the lethal weapons? There is
Let's-
only mention of one.
One. That was seized also.
Hmm.
Others were not.
One weapon, one bullet.
Mm.
Who fired? Nobody knows.
Two bullets, one bullet was inside, it could not be taken out, and the other bullet had been out. So but others have sustained bullet injuries.
How is it possible?
Others have also carried bullet unregistered.
But that was not seized.
That was not seized. Must have carried by them.
If your Lordship permit, may I read one line of cross of PW 11, one paragraph from my compilation of PW 11, cross serial number 10. Only that.
Mr. Ahmed, we will only go by this because judgment is not here.
Lordship.
So we are not touching it. You have to show from the judgment.
Because in the charge sheet also just
11 in cross
in charge sheet
examination.
also they said Lordship that DK Namse in self defense fired and others were present. That only the truth that part. Charge sheet.
Yes, this is at page number 25, cross examination of PW 11. Page 25, last sub paragraph.
Page 25
Of the memo of appeal.
Page 15 of the judgment.
Yes.
The sub-paragraph, Lordship will see that in his cross-examination stated that in the charge sheet being submitted in the instant case, it is stated, it is in the charge sheet,
Yes.
that on seeing accused DK Namse, other charge-sheeted accused person raised protest, and then the complainant and his party became violent and set fire to a hut of DK Namse, who then finding no other alternative for his self-defense started gunfire from his issued gun upon the fellow of the complainant. And this one was rejected by the trial court.
PW 11 is the IO.
Lordship.
Hmm.
But IO was not present in the, any eyewitness here, this is all
Because-
circumstantial evidence.
Because he's, when he surrendered, Deacon Amse when surrendered, his plea was that he used the gun for self-defense. In that process, that deceased died. That was his plea. Therefore, charge sheet was submitted in that way. And unfortunately, that Deacon Amse died before the trial proceeded, Lordship, so that remains.
But case rests on ocular evidence. The injured witnesses have named these 3 persons to have fired.
All right. So what is your submission, whether
That's
this is a
the-
case for bail or not?
Section 149 is there,
Hmm.
and 49 was simply to attack, and they had used it ultimately. So other injured witnesses are there who have seen these 3 persons coming in the mob, all of them together with armed weapons. That shows the object, and then they have fired upon all. And specifically, they have named, as far as Bijoy Amse is concerned, Bijoy Amse, Lordship is the person who has named him. PW3, he had gone for work, he had named him.
Yes, but he said they were firing indiscriminate.
Indiscriminate firing. From whose gun deceased died, nobody could say.
That is the main evidence against these 3 persons, that they were firing indiscriminate.
Simpliciter 302 evidence is difficult. Only by bringing 149, we can somehow.
That is correct, but whether, see, whether the object, common object was to kill that person, the object will have to be to assess, to kill that person, to commit homicide.
But then no, there are
No other
judgments.
object will be a common object.
But then Lordship knows, even if the common object was not to kill, but to attack,
Hmm.
but they were carrying weapons which could kill someone. Ultimately, that becomes a common object.
But that is a matter which has to be established. The
Established.
Judgment does not
Huh.
throw light on that. All right, next matters. We'll pass
Lordship.
in order.
Had to do. Item 16.
Lordship made places. Lordship, in this matter, a medical report was called for from Superintendent District Jail, Haflong, my lord, has come, your lordship. The patient is suffering from diabetes mellitus, your lordship, with neuropathy and needs regular medication. And her condition might worsen, my lord, reported. This report is based on recent clinical examination. Earlier a report came, your lordship, that was not very clear. So this honorable court, by the order dated 34/2024, directed us to obtain the recent report on the basis of recent clinical examination.
So what is the prayer in this IA?
Here, the prayer was not there for medical, on her verbal prayer, lordship, on this honorable court directed to obtain.
No, is there a IA for granting?
No,
bail?
no, for treating an application is there, but no contention as regard medical.
Your Lordship, I have
Condition.
submitted an additional affidavit, Your Lordship, on the 2nd of May, Your Lordship, but it has not, it has not come on record, Your Lordship. The additional affidavit regarding the consideration of the health of the appellant, Your Lordship.
Have you received a copy?
No, what's the additional affidavit? এখন নহয়। এখন নহয়। Lordship have not But Lordship, off the record, the superintendent has verbally informed me over telephone, the condition of the patient is not good, my lord.
Mm.
She's suffering from severe diabetes and she can, because of a poor economic condition, as the jail could not provide diabetic food, my lord. And she's unable to take healthy diet as per medication or whatever, because
So
she's
you are
suffering.
supporting the prayer for suspension of jail.
Because verbally he has informed me her condition seemed to be not good, my lord, because of the health condition, diabetes, my lord. And jail do not have in-house doctor.
All right, we'll pass an order tomorrow along, let it be listed along with.
Yes,
Additional
yes.
You take down Miss
S Nazneen.
S.
Nazneen.
Nazneen, Learned Counsel for the appellant stroke applicant submits that she has filed an additional affidavit on behalf of the applicant on 2/5/2024, but the same is not on record. Ms. Bhuya, Ms. B. Bhuya, Learned APP Assam, has produced a report from the superintendent of the Haflong jail, which prima facie goes to show that the medical condition of the petitioner is not good, and she may require further treatment for her survival. Ms. Bhuya, however, submits that she is not in receipt of the additional affidavit filed by the applicant. Registry to therefore list this case again tomorrow for orders by tagging the additional affidavit with the record of the case. We'll pass an order tomorrow.
No.
Meanwhile,
Yes, Your Pleasure.
the report submitted by the superintendent of Haflong jail is taken on record.
Aflong sub jail. ma'am, it's a
Haflong
sub
sub
jail.
jail is taken on record.
Next.
Give you-
This will also go with that series, single bench matter.
May please, your lordship. My lord, after some time, my lord, Mr. S. Thakur is on legs, my lord.
Mr.
S. Thakur, my lord, the conducting council, my lord.
This is,
It should have also have been within the list, the other matters.
correct, let them come,
My lord.
it will also go with those series.
Item 19. Lordship, this matter was heard at length by another bench. Lordship, and the matter has been fixed today for further hearing. But that bench is not available right now.
Is it parted? It is
It
mentioned.
is written in the order sheet for further hearing.
The order is there, man.
Yes, sir. Order dated 24/4. What is it?
It says further hearing.
Mm.
Parted we want.
Actually, there were 28 witnesses, man.
Ah.
Almost 22 witnesses we have already covered.
He has done his part, half done his part. I have not started.
Take down. Mr. B. Borua, Learned Counsel for the appellant, as well as Ms. B. Bhuya, Learned APP Assam, have both invited the attention of this court to the order dated 24/4/2024, passed in this proceeding, to point out that this appeal has been substantially heard by a coordinate bench, and the matter was fixed today for further hearing as a part-heard matter. Full stop. It is further submitted that there are 28 witnesses examined by the prosecution side, and the appellants have already addressed the court on the evidence of as many as 26 witnesses. Full stop. Taking note of the submission of Learned Counsel for the parties at the bar, and the order dated 24/4/2024, we are also of the prima facie opinion that this is a part-heard matter before another bench. Registry to therefore take necessary steps for listing the matter either for listing the matter before appropriate bench or for obtaining necessary approval of the Honorable Chief Justice for having the matter released from the coordinate bench so as to enable this bench to take up the hearing afresh. Please take order.
Obliged.
Supplementary list for orders, item 20.
What is this?
My lord, yeah, my lord, I have filed an IA, my lord, seeking a temporary bail for 30 days because on 10th his sister's marriage is there, my lord. And so far, my lord, lordship, can you have a look the IA 419, my lord?
Your client
His
is
contact
guilty
was
of
not
a
bad,
heinous
my lord.
crime. He has been convicted.
He's a convicted, my
Somebody's
lord.
sister has been eliminated.
Yes,
You can argue, we'll pass the order.
I have not received a copy of the IA, my lord, 419, because I have only filed the Wakalapa on Monday, but I've been newly engaged as informant.
Plus the 389 application, I'll file my objection. I have not filed.
that is there, my
But
lord.
interim bail, he is seeking that.
Only, my lord.
You argue, but see the circumstances of the case. He has been convicted again after being remanded by this court.
My lord,
Life.
his lordship has remanded back the matter, then my lord again convicted, against which I am before your lordship. And
All
there
right,
is,
that we'll see. If the conviction
there is, my lord, already IA is there, my lord, pending in that case seeking suspension of the judgment as well as the bill. Yeah, my lord, instantly, IA we have filed for consideration of bail for temporary period of 30 days on the account of his sister's marriage on 10th, my lord, day after tomorrow.
Had it been some death or so, could have
That
been
is my-
considered, but
Otherwise, from
just a minute.
sister was also convicted.
একটু acquittal দিলে acquittal দিলে মাকু দিলে না এই শ্রদ্ধা কেস আমার নম্বরটা দিয়ে দেবো
Yes.
So, my lord, matter was remanded back, my lord, then he was convicted, my lord. And during his, his judgment, my lord, impugn judgment, he was languishing in the jail, my lord, and he has undergone, my lord, various courses also, my lord, and jail authority also issued the certificate. Lordship, can you have a look, my lord, for a moment, my lord? IA
What
419.
he is saying that he has not received the.
That's what, my lord. Immediately after tomorrow, my lord, the IA will be infectious, my lord. because
Marriage
Marriage on
was fixed perhaps 1 month back or so.
No, my
Now,
The application only on 2nd of.
now at this nick of time, they have filed the application. And we don't have any information whether the marriage is there and all.
No, this is there.
Had it been some death in the family, matter would have been considered, but marriage of the sister who was once convicted, of course, lordship is the author, lordship had acquitted her.
Victim was also somebody's sister.
That's true.
So you want to serve him a copy or you want to order today itself?
I'll serve copy, my lord, if your lordship fix the matter tomorrow, my lord. Because
Because
immediately-
I'll be in a position to file an affidavit by tomorrow.
because my lord, on 10th, after 10th, this IA is the infectious.
Maybe.
Only option is left out, my lord. Our lordship can take over the second half. I can supply him copy right now. my Because his name was not
Yeah,
compatible in
the
this.
learned counsel for the applicant also heard Mr. S. Jahan, learned APP Assam, appearing for the state, Mr. A. Otol, learned counsel for the informant. Submits that no copy of the IA has been furnished to him, as a result of which he is not in a position to respond in the matter. A copy of the IA be furnished to Mr. Otol. Let this IA be listed again tomorrow for orders. Let this IA, let this matter. What is this revision petition? CRP before division bench?
Ma'am,
Why?
well, that's a custody matter. Ma'am. The visitation right has been granted to the father, my lord, every alternative Sunday. The matter is pending before the family court, my lord. And that's why, my lord, they have filed a revision against that order, my lord.
No, the petitioner is,
My lord, the father. Hiranmadev, my lord, father. Here the petitioner is the grandparents, my lord. The original petition in the, my lord, family court, my lord. The father has sought custody, my lord.
Pen drive and pen drive.
The grandparents are before your lordship, my lord.
Pen drive.